After Padilla was recruited, he was trained in 2000, 2001 in Afghanistan and Pakistan in various subjects, including how to blow up apartments and the buildings containing them in a particular way. He also developed a fascination for the idea of an improvised nuclear weapon, later toned down to a relatively primitive device, using uranium wrapped in conventional explosives to create a so-called dirty bomb, which creates not much in the way of an explosion, but a great deal in the way of radiation. By April of 2002, he was ready to travel to the United States. On this odyssey, he had met and won the confidence of a virtual dream team of world-class terrorists. That information came in part from the harsh interrogation of Abu Zubaydah, one of the high-ranking al-Qaeda members I mentioned a moment ago. When it was clear that Padilla would not testify against his cohorts, he was transferred, on order of the President, to military custody as an unlawful enemy combatant, which was a designation that was not invented in 2001, but was a designation that had long applied to anyone who did not fight in uniform, participate in a recognized chain of command, carry weapons openly, and refrain from targeting civilians. So let's review this brief and somewhat sanitized history and spot some issues: constitutional law, evidence, criminal procedure, the limits of executive power, to name only a few legal issues. We could at any time declare that we are not in a war. That would not change the view of our adversaries, who declared themselves to be at war with us in the 1990s and proved it, with the first World Trade Center attack in 1993, with the bombing of Americans at Khobar Towers in Saudi Arabia, with the attack on the Cole and the attempted attack on another destroyer, with attacks on our embassies in Kenya and Tanzania, and so on. We responded to each of those with conventional criminal prosecutions. And then, of course, came the September 11, 2001 attacks. You who aspire to be judges, defense lawyers, members of the executive or legislative branch, prosecutors, lawyers of any kind, may wish to ponder the question I raised earlier, whether or not we need a different system of courts for such a conflict. And if so, how would it differ from the conventional Article III court? And if necessary, how could we create it? This involves both legal and policy choices. All of these legal questions must be resolved in ways that are consistent with our Constitution and other laws, and the policy questions in ways that are consistent also with our values and our interests. Throughout these remarks, I've tried to separate out legal and policy issues, and I think for good reason. Any good lawyer who understands that the decision he or she makes may be scrutinized in the future will understand that as to legal questions, that lawyer has no alternative except to do law. Hard though it may be, a good lawyer must be indifferent to the fact that the lawyer may well be criticized, whatever the decision. It is the task of the good lawyer to tune out all that noise, to give the best reading within that lawyer's ability of what the law is, and not to confuse the law with what that lawyer or someone else thinks it ought to be. If the lawyer's best reading of the law permits some policy, there is a professional obligation to say that it would be lawful, even if the lawyer personally disagrees with it, or recognizes that it may one day prove controversial. Just as important, perhaps more important, if the lawyer believes some policy would be unlawful, there is a professional obligation to say no, even if some people think that the policy is desirable, even critical. The rule of law and the oath every public servant takes to support and defend the Constitution depend on it. And law, it must be remembered, is not simply an empty vessel into which a lawyer pours his or her opinions on matters of policy. Although only some of you are likely to become public servants, and some lesser number to deal directly with these precise dilemmas, the responsibility to do law will apply to each of you. The lawyer in private practice must not confuse his client's interest with the law. If no is the right answer, the obligation is to say no, even if the client doesn't want to hear it. The lawyer pursuing the public interest must not confuse her own views of what the law ought to be or what it is. And the lawyer in robes, as I once used to be, as many graduates of this fine school are, and as some of you no doubt will be, like the image of justice blindfolded, must decide cases, as the federally prescribed judicial oath says, without respect to persons. It's an interesting formulation. That is, without regard to who the parties are, or what outcome might be well received in some quarters, but based on the judge's best reading of what the law requires. I have not here suggested answers to any of these questions, although obviously I have views on some of them. Some such views already expressed, others not. Today I've simply done what each of you graduating today has been asked to do on final exams over the course of your law school careers. I've spotted some issues. A few are straightforward legal issues that can be resolved by consulting the law. Others are policy issues which should not be confused with and dressed up as legal issues. You and other law graduates across this nation will help resolve those issues and hopefully keep separate the legal issues and the policy issues. On a final exam, spotting issues alone can get you a high grade, but in the real world, it can't. Difficult issues have to be resolved, and your training over the last 3 years in recognizing and drawing distinctions between law and policy, in separating real differences from bogus ones, in understanding legal principles, and the enduring values and practical ends they're supposed to serve. That training and the skills that you've acquired as a result will be absolutely essential if we are to resolve these issues in a way that we can all live with, in all senses of that phrase, including being able to abide the result as moral beings, and being able to keep ourselves and our neighbors safe. Here it is useful to bear in mind the lesson taught by a French philosopher named Pascal, who said that the first rule of morality is to think clearly, and also the first lesson taught by many others, that in order to think clearly, you have to write and speak clearly. That's why we all have need of your skills in the years ahead, regardless of whether or not you pursue a career in government, in the private sector, or in some combination of private and public work. I don't for a moment pretend that there aren't many issues and questions, or that the answers are easy. Indeed, one of my partners, Mary Jo White, who served as U.S. Attorney for the district where I sat as a judge, delivered a speech on some of the issues I presented in these cases and these remarks. She called it, this was the title of her speech, Terrorism and Civil Liberties. The questions are many, and the answers are hard. But your participation and the participations of others like you in the national debate on these and other issues will help assure that we arrive at conclusions that, as I said, we can all live with. I wish you, all of you, and each of you, the greatest of success in your careers and in your personal lives, and I thank you again for the opportunity and for the great privilege of addressing you today.